car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis, Wright, and host David Lamb.
Hello and welcome into The Attorneys. Thank you so much for spending your evening with us tonight. Our topic of conversation is workers' compensation and what are your rights. You're going to spend about 2,000 hours a year on the job, so you need to know your rights in case of injury there, and that's going to be our conversation tonight here on The Attorneys. We have a panel of experts ready to take your questions and your calls, and here's how you can join that conversation. You'll see the information on the bottom of the screen, ways you can call, text, and email, and also a reminder, attorneys are standing by to speak with you live right now, so take advantage of that opportunity for some free legal advice. Now, leading our conversation, as he often does from the firm of Hollis Wright, is Josh Wright. Good to see you, sir.
Good to see you, too. You know, there are some people that actually would jump up and down and get excited if they only had to work 2,000 hours during the year.
You think so?
No, absolutely.
Probably attorneys.
No question, no question. You know, we're going to be talking about workers' compensation. We have one of our good friends that's been on the show several times, Allwin Horn. Allwin does a great job, understands this area of the law, and when we have workers' comp-based issues, we go to Allwin. You know, there's some interesting statistics as we do these shows. 5,000 workers across the country are killed every year in work-related accidents where workers' comp could be implicated. In Alabama alone, there are around 15,000 to 20,000 first report of injuries, which are reportable injuries that happen in a typical year. So this is something that impacts a significant sector of the society, especially here in Alabama with all the industry and the things that we have. So we're going to kind of be dissecting and working through some of the issues related to workers' comp and how somebody takes advantage of it, how they report a claim, those types of things. So once again, as always, a good friend of the show, Allwin, thank you for being on. We really appreciate it.
I appreciate y'all having me. I look forward to it.
So let's kind of start this thing off from the 10,000 foot view. In general terms, does workers' comp apply under all circumstances if you're an employee, or are there some limitations?
I'd say there are very few times it doesn't apply. Typically, if you're doing something, the simple way to put it, beneficial to your employer, if you're on the employer's premises during your work hours, or even sometimes off your work hours, if you're doing anything, you know, beneficial to the job, you're going to be covered. You can have a traumatic injury on the job. You know, you may be on a construction site, you may fall from a ladder, you know, something that's quick, a quick related injury. You could be in your vehicle driving for your employer. You know, anything related to the employment's going to be covered. There also are things that you may consider social. For example, I mean, you have to go to the restroom while you're at work. You have to eat lunch. If you're required to eat lunch on the job site, or if you're limited or directed as to where to go and how to do that, you're going to be covered under those circumstances as well.
I get a lot of questions at work related to, not my work, but people calling that are clients about two issues. Number one, is it a no-fault system, meaning, you know, if I'm at fault and I cause this injury, can I still get workers' comp? The second issue, and I want you to address both these. So the first is no fault, but the second issue is this is a small mom and pop entity. We've only got 2 employees or 3 employees. Does workers' comp apply? Can you just kind of address those? Because I know those are probably questions you get a lot.
Absolutely, and that's key to the analysis. First of all, it is a no-fault system. You can cause your own injury, or nobody can cause your injury, and it's going to be covered as long as it arises out of the course of the employment. That's key. The trade-off is that as long as you're hurt during the work, you know, your damages may be, your recovery, your compensation may be kept down, but your medical benefits are always going to be provided, and I know we'll talk about that differently. But also, any employer that has 5 or more employees is required to have workers' compensation coverage. If they don't, they can be hit with a double penalty.
Yeah, and I was going to ask you that because I've seen circumstances, I know you have too, where an employer did not carry workers' comp. What does happen in those circumstances?
Well, typically there's a set schedule, or there's a formula in which compensation benefits are calculated. They can be hit for double that amount. A court can award double the amount of the actual recovery to the employee.
Our first question of the night, this one comes from the email firm@hollis-wright.com, and the question is this: I've been injured on the job. What type of benefits am I entitled to?
Well, let's kind of go over them. I think there are 3 or 4 basic classifications you can put. First and most important is you're entitled to medical benefits, and that's the most important thing in my opinion. When you're hurt on the job, you need to immediately report it to your employer, because as time passes, the waters get muddied, and you know, people want to say maybe you didn't get get hurt at work. So report it, go to a doctor, get your medical treatment. The next thing is if you have to come off the job or if you come out of work, then they have to pay you a percentage of your average weekly wage. So you're entitled to compensation benefits while you're out of work. And then you're also entitled to some form of permanent benefits for any type of permanent injury. And if you can't go back to this type of job because injury prevents you from returning to that line of work, it may be too physical for you, you can't physically do it anymore, you're entitled to a form of what's called vocational retraining or a vocational disability rating. And then your employer or their insurance carrier, so to speak, would actually have to pay you to go to some type of another school to learn another trade.
Now, is it just injuries where somebody is physically injured, or are there other types of injuries that could be applicable?
You know, it is not. And I assume when you say physical, like a traumatic, immediate injury. No, you have other injuries referred to as repetitive stress injuries. If someone, you know, we have a lot of people that work on conveyor lines, or they're in packing or boxing or installation, and what they do with their hands are most common. People develop what's called carpal tunnel syndrome, and because what they're doing, they're engaging in the same motions 500, 800, 1,000 times a day, and it causes injuries to certain parts of their body. It's called a repetitive motion injury, and as long as and let's just put it basically, those are covered as well, other than traumatic injuries.
You think these things can be handled by the employer or and the employee individually, or do you recommend getting a lawyer involved? How do you recommend it?
You know, I've been doing this since 1997, 1998, and I absolutely recommend you get a lawyer. The reason being, you know, you have so many people, honorable people, hardworking people that have been with the same employer for, you know, 10, 15, 20 years, and they want to do right by the employer. They don't want to cause what they would consider trouble by getting a lawyer involved. But these employers, 90 to 95% of the time, even 100% of the time, they're going to have either a third-party administrator or an insurance company who is going to handle the claim. And they're in the business of making money, and they're in the business of keeping their money with all those premiums that the employer pays. So their goal is to try to limit the health care and limit the compensation so they maintain their bank account. And you need somebody looking out for you and your rights, because the employer has somebody looking out for them.
Right. Another question we have from a viewer here: if I cannot work due to my injury, how will I be compensated while I am off work?
You are entitled to what's referred to as temporary total disability benefits if you cannot work at all. If your injury, if a doctor gives you an out-of-work excuse, and you have to be out of work per your doctor or a doctor, it gets a little more complicated if it's not the authorized doctor, but you are entitled to 2/3 of your average weekly wage. That's referred to as temporary total disability benefits. Let's say you have you are able to go back to work, but you can't do the same type of work you are doing. You're put on light duty. Then you will receive, and your rate changes. You will receive, let's say it's the light duty rate is $5 less an hour than your regular rate. Well, then workers' compensation has to step in and pay you 2/3 of the difference between the $5 less and what you would be making normally.
So,
and that's referred to as temporary partial disability benefits. You're partially disabled during this temporary period.
And there are some other examples. I mean, there's temporary total. I mean, there are a couple other.
The temporary
scenarios.
total is when they pay the 66% while you're completely out of work, and then once you get maximum medical improvement from your doctor, you know you're released. You're as good as you're going to get. You're entitled to some form of permanent disability benefits. It could be permanent partial, meaning you have some percentage of disability, or vocational loss, but you're not 100% disabled, and then you get permanent total disability benefits, which would be basically 2/3 of your average weekly wage for the rest of your life.
Is that qualification, whether you're permanently injured or you're temporarily injured, are those classifications based on the lawyer and the client, or are those things that are defined by the code?
They're defined by the code. The Alabama
plug them in?
You absolutely plug them in, and you know we hire experts here at our firm. You know, vocational experts, functional capacity evaluating experts, which are typically physical therapists, to determine what type of physical limitations there are, and you take into consideration a person's past job experience, their educational level, and whether or not they are capable of being retrained to do something else. They may have no transferable skills.
I know we're getting ready to go to break here, David, but I want to talk about when we get back a couple things. One is I want to dissect that issue a little bit more about how someone's classified as permanently injured versus temporarily injured. In addition, I want to talk about the exceptions to the no-fault system. There are a couple exceptions that Allwin and I can talk about We'll talk about those things when we get back.
All right, let's step aside our first break of the evening. As we do so, a reminder, call, text, email, get those questions into us. We'll be glad to pass those along to our panel of experts tonight. There you see the information of how you can get in touch with us. And a reminder, attorneys standing by right now to speak with you, 844-LAW-TALK. Stay tuned. More of the attorneys coming right up.
I'm Carter Clay with the law firm of Hollis, Wright. Thanks for watching The Attorneys on WVTM 13. Now we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of this show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other specific legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family member. Or simply contact us by going to WVTM13.com and click on the attorney's link. Now we know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on WVTM 13.
Welcome back into the attorneys. Thank you so much for spending this evening with us. A reminder, we'd love to have you join the conversation. You can call, text, email, and you see all that information there at the bottom of your screen. Josh?
All right, so when we were going to break, I wanted to make sure that I didn't forget for us to talk about, there are a couple examples that are exceptions to the traditional thought that workers' comp is a no-fault system. Can you just kind of talk about those? I know they don't come up a lot, but they are applicable for your evaluation on these cases.
Absolutely. There's one section in the code, and I want to say it's, code section 25-511, and there are 3 or 4 different categories of actions that an employee can engage in that would deny them workers' comp benefits. They're affirmative defenses, and one is if they're intoxicated on drugs or alcohol at the time of the accident. Now, a caveat to this is, there are requirements under the Workers' Compensation Act. Every employer is going to send their employee to the hospital when they're getting medical treatment. They're going to be drug tested at the time. If they have drugs or alcohol in their system, the employer still has to prove that they were actually intoxicated or under the influence or impaired at the time of the accident for the claim to be denied. So just because you may have alcohol or drugs in your system that something may have occurred 6 weeks before doesn't automatically mean your claim is going to be denied or is due to be denied. There's also failure to provide or failure to wear like a safety device or manipulate a safety device that's provided, say a harness system. You aren't tied off, you're working for heights and you refuse to wear your safety harness or tie off. That could be a denial. And then you have other situations where Josh, help me out here.
Well, I mean, those are the primary, but I was actually going to ask more about that.
Some employees, believe it or not, try to commit suicide. That's what I was trying to think. Some people will get in a car and drive in front of a truck, and if it's deemed they're trying to commit suicide or intentionally injure themselves, those are not applicable.
All right, this is where I think getting a lawyer is super important, though, because you talk about safety harness, and we've had you and I have had cases like that where somebody may think they have their safety harness on versus the affirmative, I'm not wearing my safety harness. I mean, as a lawyer, you've got the ability to negotiate some of that, don't you, to prove that this employee wasn't intentionally doing this. It was an accident. It wasn't their fault.
That is exactly key. It has to be an intentional act of knowingly failing to do something. You assume the risk and you understand the consequences of your action. You're knowingly to do it. There are certain fact patterns that will arise where an employee has to engage in an activity quickly or something to where they're not that they are not saying I just don't want to do this. I don't want to wear my safety harness because I don't like it, and an accident happens because they didn't have the time or they didn't get to doing it.
We were talking in the commercial. I thought of a friend who was injured on the job and has been out of work now for a good little while. But it made me think about statute of limitations. Is there a time limitation or kind of some rails there in terms of when you must report?
There are, and depending on the type of injury you have, let's say, for example, it's a traumatic injury, an injury where, that immediately happens at the time of the accident, then that's 2 years from the date of the accident. Or if you come out of work for that accident or injury and you're paid those temporary total disability benefits, it's 2 years from the last date you were paid those benefits. Okay, now if you have a repetitive stress type injury, you've been working at a chicken processing plant for 15 years and you've developed problems with your hands or your shoulders, it is 2 years from the date you last worked or were exposed to that repetitive nature. If you have a chemical exposure injury, and there are a lot of those dealing with lungs, heart, head, it is 2 years from the last date you were actually exposed to that chemical, for example, working in the plant.
Yeah, and let's talk through that just a little bit more. There are circumstances where you've got to actually prove that a chemical exposure caused your injury, though, right?
They are, and in all workers' compensation cases, you have to prove what's referred to as legal causation, and that is that the job caused the accident. The job caused the injury. It arose out of the employment. The second burden of proof is that you have to prove medical causation, and that is the injury you're complaining of was actually caused by the job. So in chemical exposure type cases, you're going to need an expert of some type. Typically, it's going to be a doctor to testify that whatever you were exposed to did in fact cause your condition.
And I'm assuming that's one of the other reasons why we would get an attorney involved quickly, so that the attorney can actually kind of explain those two causal connections that are required and go get the experts to be able to
Absolutely, because I tell you what, one of the downsides, in my opinion, of the Workers' Compensation Act, the upside is that the employer is always responsible for medical for life as long as it's job related. Yeah. But the downside is that the insurance company for the employer is going to pick the doctors, and a lot of times they have a relationship that may result in a biased opinion. So you need to get to an attorney that makes sure you get to the right type of doctor, you're seeing the right doctor. And if you're dissatisfied with your doctor, you do have a one-time choice to get a panel of 4 doctors that are like physicians, similarly situated doctors.
You think going to another set of doctors through your lawyer sometimes can increase the value of the case?
There's no doubt in my mind. I mean, you have, again, we go back to these employees that want to be, quote, loyal or to their employer, and they don't want to cause any trouble. They follow their lead, and the next thing you know, they're potentially without a job and without any benefits, but they still have significant medical problems.
This is why we bring Allwin on the show, and it's explaining to the viewer the importance of getting counsel involved early, because it really can increase the total value of your case, David. When we come back, because I know we're about to go to break, I want to talk about retaliation. There are employees that have been employed for a very long period of time. They're afraid of retaliation. Sometimes they're employed for a really short period of time and they're concerned with retaliation. And I want to talk about exactly what types of claims are applicable in those circumstances. And I want to make sure employees understand and recognize that the law doesn't allow the employer to retaliate against them just because they filed a workers' comp claim.
All right, on that note, we'll step aside. Our final break of the evening. Just a few minutes remaining for you to get your questions into us. Also, a reminder, you can check out the firm on Facebook, Hollis Wright. Just search that, or Twitter. It's Hollis_Wright. Stay tuned. The final segment of The Attorney is coming right up.
I'm Tyler Vale with the law firm of Hollis Wright. As with any industry, it's important in the legal world to hire an attorney that is knowledgeable and has a track record of success. But with so many attorneys out there and so many different types of cases, how does someone decide the right lawyer to hire? In this week's Legal 411, we're answering the question, what should I consider in hiring an attorney? In-state versus out-of-state, big firm or little firm, recommendations from friends or family, the internet, the phone book, or TV. With so many choices and so much information, it can be an overwhelming task trying to make the right decision. To complicate things, choosing a lawyer is an important and sometimes life-affecting decision and should not be taken lightly. So how do you select an attorney? Do your research. Look the firm up on the internet. Ask friends and family whether they know or have any experience with a specific firm. If you know any local lawyers, ask them about the reputation of the firms you may be considering. Call a local law office and ask if they are handling cases like yours. There's a good chance they can help you. But if they can't, they can always refer you to someone they respect who handles your type of case. And remember, ask questions face to face. Ask about their experience in handling cases like yours, how often someone from their office will be available to you, and what you can expect during the process. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you.
Welcome back into the Attorneys Hour, final segment. So if you have a question, would love to have you call, text, email us. Also, attorneys standing by right now to speak with you. Give them a call as well. We've spent a great deal of time tonight talking about workplace injuries, but I'm just curious if say someone gets killed on the job and there is a death, what sort of benefits would there be to families in that case?
Good question, and we didn't cover that earlier, but very, very important. Typically the rule is that, a surviving spouse is entitled to 66%, well, I'll take that back. Their percentages set out whether or not they're just a surviving spouse or they're also dependent children or dependent adults, but I think the rule of law is right now you got to be, 18 years or younger to be dependent. And it's not necessarily living in the same household, but at the whole time, it could be that they are dependent in that they are assisted in being provided financial assistance or aid. You can have college students that could be dependents, but they're entitled to 500 weeks of death benefits, which is going to be anywhere from 50 to 66% of the average weekly wage of the decedent employee.
Let's talk a little bit about retaliation, because when we were going to the last break, I had mentioned the issue of retaliation. I know it's a question you get a lot, we get it a lot at our firm, related to whether or not an employer, where an employee is made a workers' comp claim, whether or not they can be retaliated against. And let's just generally kind of unpack that, because I think it's a critical issue that people need to understand.
It is, and people are scared about losing their job for filing a workers' comp claim, like we've been talking about upsetting their employer. But generally speaking, Alabama is what's referred to as an employee at will state. That means that an employee can be fired for anything, for any reason, or for no reason at all. They can just be let go, and there's no legal consequences to the employer. However, there are exceptions. Of course, you have your federal laws that protect against discrimination for age, sex, race, things of that nature. But in Alabama, one of the only things an employee can sue an employer for, other than workers' comp benefits, is going to be what's referred to as retaliatory discharge. They are fired by their employer for seeking workers' compensation benefits and filing a claim. How
do you prove those claims? Because I can see where that could be difficult at times.
It is difficult to prove, but you have to prove. The burden is very difficult on the plaintiff, the employee, or their attorney, because you have to prove the sole reason, the only reason that they were terminated was because they filed that claim. And now typically, an employer will come up and say, well, we have a laundry list of reasons we wanted to fire this person, we just hadn't done it. But that's a rebuttable presumption, meaning that we, the attorney for the employee, can come back and say, well, for example, if you had all these problems and all these issues before, why didn't you do it then? You can rebut that argument.
So, at the end of the day, there's statutory authority and probably case law in Alabama that gives some teeth to the retaliatory discharge claim, where the employer recognizes if they fire somebody related to comp and the person has a lawyer, they can be sued for it.
Absolutely right. You know, if an employee is willing and able to return to the job and they're terminated for some bogus reason, then there is absolutely, under the laws of the state of Alabama, they can file a claim for retaliatory discharge, but they have to meet that burden of proof, and proving the only reason they were terminated was because they sought workers' compensation benefits.
Allwin, talk if you can just for a minute about the issue of whether or not somebody can be returned to work in a different capacity that they started from.
That's a good question. They can be returned to work. Let's put it this way. The employer is not obligated to, quote, accommodate somebody. If you have restrictions because of your injury that it prevents you from going back to the same type of physical stress level or physical demand level, the employer is not required to accommodate you and give you a lighter physically demanding job. They don't have to do it. At the same time, a lot of the times an employer wants to do that until you settle your case, because if they acknowledge you can't go back to that type of job, you have a vocational loss and a vocational disability, which really increases the value of your compensation.
David, I want to talk just for a minute about third-party claims. Okay. And this also kind of underscores and highlights the reason why you want to get a lawyer involved. Allwin and I see cases all the time. In fact, we work on cases together where it started out as a workers' comp case, but it ended up being a workers' comp plus a third-party claim. That means that there may be a third party that is responsible for the injury sustained by the individual. There are also there's a concept called co-employee cases, where there may be some circumstances where outside of comp, it's really in comp, but you can get outside the confines of the damages you can get in workers' comp by bringing a claim directly against a co-employee. So the important thing there is this. You want to have the case fully and completely evaluated, because if it turns out that you were injured, for example, on a piece of equipment that had a defective gate on it or a defective component to it, that piece of equipment, that manufacturer, and that co-employee that may have taken a guard off, for example, could all be responsible to you above and beyond what you get for workers' comp. And Allwin sees those cases every day. We see them, and like I said, we work on those cases together. A lot of times he'll come in with us and say, hey, will you evaluate the third-party claim? Well, I handle the comp claim. So get a lawyer involved. Doesn't cost you any more money to do it.
We're just about out of time, but want to get both of you on. Maybe that's where you want to end. Allwin, but for you, a final thought.
I think that's a real good point to end on, is because number one, you do want to get an attorney involved primarily to look at every avenue of recourse, whether it's, you don't want to be limited to workers' compensation because your damages or your compensation is set and it's low. The trade-off is you get your medical benefits. So you want to find every single claim or every single responsible party and pursue them. And one of the significant differences between a third-party claim or a negligence claim against someone else as compared to a workers' comp case is that in a workers' comp case, it's like the damages are set.
Right. You
plug in numbers and a judge makes the decision.
Yeah.
In another case, in a third-party case or negligence claim, you have a jury that's going to award your damages.
Yeah. Great point. And I'll be quick too, because I know we're close. You know, there's a reason why we brought Allwin on the show 3 times. Yeah. He is a preeminent expert in this area on this stuff. This is what he does for a living. If you're sitting there at home and you've got an issue, you've been injured on the job, let us know. We will get you in touch with Allwin. Call us, email us, text us. We'll get you in touch with him, because he's somebody you want to talk to be able to kind of work your way through this process, and it doesn't cost a lot of money to do it.
All right, we're out of time, fellas. Thanks so much
Thank
for
you
the
so
time.
much.
Appreciate you joining us as well. We'll see you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.